Hello, I'm Josh Johnson, and this video is on first-time misdemeanor DWIs in Minnesota. So the first thing that you need to know about DWIs in Minnesota is that there really are two cases that are going on with a DWI, not just one. So the first case is the case that we all recognize as the traditional criminal case where you're going to court and there's a question of whether or not you can be convicted of this offense, whether or not the state can prove that you were driving while you were intoxicated or over the legal limit beyond a reasonable doubt. And if they can prove that, and if you plead guilty or are convicted of that offense, then what the consequences would be. Would there be any jail? What would the fine look like? Would there be other conditions of a judge's sentence that are part of that final result? So that's the criminal case, and that's what we all traditionally understand is going on with a DWI file. The other thing, though, is that in Minnesota, we also have an implied consent case, and this is a pretty unique thing to Minnesota. Here we have separated out all the driver's license issues and plate impoundment issues and civil aspects of your driver's license into this case, which we call your IC, or your implied consent case. And that has a separate civil file number. It's held at a different time at court. And in fact, you only get to even have an implied consent case and argue about your driver's license revocation or plate impoundment issues that might be going on if you affirmatively file a petition to argue about those issues. And that has to be filed within 60 days of receiving notice of the revocation. So this becomes very, very important for folks who get a DWI on the first of the month and then might not have court or even get any notice of court for some time later. The clock starts running the moment that the defendant receives a notice from the officer. And again, usually this is right in person, this is at the jail. They get handed a notice of driver's license revocation, and they have 60 days to file an implied consent petition and preserve their right to argue about the reason that they were revoked, if they should be revoked, if there are any constitutional issues that they would like to raise about that revocation. If you don't file a petition within 60 days, that issue is gone, it's waived, and you can't ever go back, no matter, even if the criminal case is in the future completely dismissed, even if it's completely dismissed for unconstitutional conduct on the part of the officer, there's just nothing you can do. You still have that alcohol-related revocation on your driver's license, and if it's a misdemeanor case in Minnesota, you're going to have that revocation of 90 days. Now, there are certainly a lot of other details that go along with deciding if you absolutely want to file your implied consent cases. There are some times when I have advised clients about filing it, or deciding whether or not they would rather save the money and not file the petition. You do have to pay a filing fee to do it. You do have to certainly either file it yourself or hire a lawyer to do it. So it can be something that some clients don't want to do, because there's, legally speaking, no disadvantage to filing the petition. There's nothing worse that can happen from filing an implied consent petition. We almost always recommend that our clients do file it if they can afford to do so, because it preserves your right to argue about those issues in the future. If there are none, well, then you're stuck with the same revocation that you had before. But if there are some, you certainly would be potentially regret having not got the petition in within the 60-day period. So again, I think the important part of this is just to recognize that you cannot argue about your driver's license issues in a DWI case in criminal court, and you can't argue about any criminal issues that you may have about your sentence or about what they want to, what the plea agreement might be in a criminal case when you're arguing your implied consent case. It is worth noting that in the Twin Cities, Hennepin County, and Ramsey County, allow for a process of reinstating your driver's license through the implied consent process while your criminal case is going on. So it's an added benefit in Hennepin and Ramsey County to file your implied consent petition, because you very well may be able to get a reinstated driver's license for 2, 3, 4, 5 months, or however long it takes for the criminal case to resolve. And this is a huge benefit for folks who need to drive for work and maybe haven't even been formally charged in their criminal case, but would like to get back in their car and be able to drive where they need to drive for their family or for their job. So DWIs are complicated in Minnesota. They take up a big portion of the criminal code, lots of rules and statutes involving how DWIs operate, and really I advise folks to contact an attorney, contact me if you have questions about how they work and how your case is really interacts with the current laws. So I think that's a general overview of DWIs. Certainly contact me if I can be of any assistance on any questions you may have. Thanks.